Ready as we're ever going to be? Okay. Well, hey everybody. Thanks for coming to this. I'm Shannon Minter. I'm an attorney with the National Center for Lesbian Rights, and I was really excited actually to have a chance to be here to talk about this topic. I think it's so important. Hey, real quick though, will you raise your hand if you're an attorney? Okay, awesome. So almost everybody is attorneys, and I think for those of you who are not, it'll still make sense, hopefully, hopefully. But it's good to know that most of y'all are practicing family law. That's excellent. So the topic is to talk about what is the current state of parentage and family law protection sort of after Obergefell. And I wanted to say right up front, this is, to call this an evolving landscape would be an understatement. So I was thinking, this is really should be, I think maybe we should think about this more as almost like an issue spotting workshop rather than one that's going to be able to offer any definitive answers, just because this is a time of so much uncertainty and change. But Obergefell and the state marriage cases that came before it put so much emphasis on the importance of marriage for parenting law and for parents and children. I went back to look at Obergefell, and I was really struck by how much emphasis that decision placed on that aspect of marriage. The court talked about one of the bases for protecting the right to marry, I'm quoting now, is that it safeguards children and families. The court made a big point of noting that, as all parties in the case agree, many same-sex couples provide loving and nurturing homes to their children, whether biological or adopted. And so clearly the court is operating at a pretty high level of sophistication, understanding that not all same-sex couples have to adopt children, that there can be a biological relationship too. And then the court talked about the importance of recognizing the right to marry in order to take away the, quote, stigma for children of knowing that their families are seen as lesser. And then I was thinking way back to the Goodrich decision, the first state Supreme Court decision on marriage equality back in 2003. That court as well put a lot of emphasis on the parenting aspect of marriage and talked about one of the most important marital rights being the presumption of legitimacy and parentage of children born to a married couple, and that marriage was important. And the court said, even though now we try to treat marital and non-marital children equally, that marriage provides a lot of benefits to children, including the greater ease of access to family-based state and federal benefits that attach from presumptions of one's parentage. So that court just assumed that the marital presumption was going to apply to married same-sex couples. Now, I thought I would just mention that in the Tennessee case, which was one of the four marriage cases that got consolidated in front of the U.S. Supreme Court in Obergefell, that was our case. And one of the couples in that case was a lesbian couple who was expecting a child, and they had already been married and then moved to Tennessee as a married couple and were about to have a baby. And we actually got a preliminary injunction from the federal district court in that case based on the urgency of that they're about to give birth. And, we told the court, hey, they really need to both be legal parents by the time this child is born. And so the court barely made it, issued a decision literally just a few days before that baby was born. And then I think their child was the first child in the state of Tennessee to have a birth certificate listing both of the women as parents from the outset, from the time of the child's birth. I'm going to come back to that later, though, because as I'm sure all of y'all know, just being on the birth certificate is not enough to definitively establish that you're legal parents. But anyway, the point there is just that the parentage issue was a very big deal in all of the marriage litigation. So I would say, the good news, kind of post Obergefell, is twofold. One is that marriage does actually provide significant parental protections for many LGBT parents and their children, and that's especially true, really only true, in states where the marital presumption isn't rebutted by evidence that the husband's not the biological father. We'll talk a little bit more about that in a minute. Or states that have good laws about assisted reproduction for married couples. So yeah, for a lot of married same-sex couples who live in those states, it is awesome to have the protections of marriage. And it does, as long as you're in that state, resolve or provide significant parenting protections. And then the other thing that Obergefell does is just support the general position as a legal matter that LGBT parents and their children have to be treated equally, and that's going to be useful and already is useful in other contexts. Particularly, there's one state left. It's not Alabama. It's Mississippi that still expressly discriminates against same-sex couples in adoption. And Roberta Kaplan and the Campaign for Southern Equality are challenging that adoption ban and relying very heavily on Obergefell to say, hey, you have to treat same-sex couples and their families equally. So that's the good news. But the bad news, though, in this post-marriage era, is that so many people in the community, and I'm sure you all are finding this with your clients, and even some attorneys out there, think that wanting the right to marry has solved all of our family law issues and that marriage is sufficient to protect all LGBT parents. But that is, of course, not the case. And there's four main reasons why that's not the case and why it's important for all LGBT parents, whether you're married or not married, to either get an adoption judgment or a parentage decree. If you're relying just on being married to secure your parental rights, is really dangerous and it's risky for a number of reasons. I'm talking about the four reasons, but we're trying really hard to get the word out about that to the community. And I would say that many people out there do not understand this at all and don't want to, are resistant to having to adopt their own children, for example. But anyway, the first reason that it's not enough, marriage isn't enough, is that the marital presumption, which is, I'm sure you all know, is the presumption that when a married couple has a child, that the two spouses are the child's legal parents. That only applies to children generally who are born after a couple marries. So, of course, there's many same-sex couples out there who had children for years before they were able to marry, and it's so important that they understand that if you've already got kids and then you marry, that is not going to protect the non-bio parent, and you really need to do a step-parent adoption. And the second reason marriage isn't enough is that it's not clear in most states whether or how courts are going to apply the marital presumption to same-sex couples. So far we have positive appellate rulings on that in just a handful of states, really. Iowa, New York, Vermont, and Massachusetts. Denise, if I'm leaving any out, let me know. Everybody knows Denise Brogan-Cater here from Family Equality Council, who's an expert on this stuff, and you have to help me out if I'm missing anything. In some states, and that includes North Carolina, the marital presumption is rebutted by evidence that the husband is not the child's biological parent. So what are courts going to do? Courts may say in those states that it doesn't even apply to a same-sex couple because we know from the outset that they can't both be a child's biological parents, or they may say, okay, it applies, but it's then going to be immediately rebutted. This is a whole area that is going to have to be litigated state by state. I just mentioned that the new Uniform Parentage Act of 2002, that act was originally put out in 1973, and then it got updated in 2002, and it's now being updated again. There's interesting issues. Actually, right now, as we're all here, the new UPA committee is meeting and trying to figure out how to revise the Uniform Parentage Act to make it expressly clear that marital presumptions should apply to same-sex couples. But even under the new UPA of 2002, the marital presumption is not automatically rebutted by the absence of a biological tie, and it becomes irrebuttable after 2 years. So, the model law that the UPA is putting forward suggests that after a pretty short period of time, if no one's come along to challenge the husband, or for same-sex couples, the spouse, then that should be it. That the door has to be closed after that. And that also means that parent can't disavow parentage after 2 years. But not that many states have adopted the new UPA. There's about 12 that have. So second reason marriage is not enough is just that we're not really sure in most states whether and how the marital presumption is going to apply. I did want to mention a few. This is, such an important issue in some ways. For married couples, this is really where the real action in terms of litigation lies. So I want to mention a few more things. I mean, the marital presumption for same-sex couples is generally really only applies to female couples, because the way that the presumption is structured, it's basically a rule that when a married woman gives birth to a child, the husband is presumed to be the legal father. So there's not really any obvious way to apply that presumption to a gay male couple. In my understanding, my colleague, Kathy Sakamura, who runs our family law project, she's an observer at the UPA discussions, and she's been telling me they're having some pretty interesting conversations there about just trying to figure out, is there any way for same-sex couples to make the marital presumption gender neutral? And so far no one can really, there's people involved who would like to do that, but no one can really think of a way as a practical matter to make it work. So if anybody, I'd be really interested if anybody has any thoughts about that. Yeah, what do you think?
I'm curious. I mean, it didn't work, but I pled the fact that the second mom was there at the conception and participated in the assisted reproduction. Didn't work. I don't know if it's worked elsewhere, but.
Well, yes, it has worked elsewhere, and that shouldn't be a problem. I mean, applying the marital presumption to a female same-sex couple, no problem. I mean, that should work just fine, and a lot of states are doing that.
Not South Carolina.
I hear you. I totally hear you.
Already filed.
Yeah, I totally hear you. And this is what I'm saying. This is the issue that's going to get litigated. Every single state eventually, I'm sure, is going to litigate that issue. But so set that aside. It should apply to female couples. No reason it can't in principle. But it's hard it's not easy to understand how it could possibly apply to a gay male couple, because there's, it's so structured around the concept of a married woman giving birth. So that's the tricky part. Yeah.
But since most men can't give birth,
right,
and that's the underlying problem, and therefore either they bring a child into the relationship at the beginning, or they acquire a child through surrogacy or some other mechanism after they're married, why would it need to apply? Why wouldn't just the normal surrogacy laws, where you have to go through the court process and get an order of parentage, work for gay male couples in all cases anyway?
Those are the options for gay male couples, either adoption or surrogacy law. Now, surrogacy law is different in every state. I mean, it ranges from, it's criminalized in some states. Some states just do not address it at all. And then some states are very friendly to surrogacy, and you can get a pre-birth order saying that the intended parents are the legal parents. So that's, those options exist for most gay men. Not all, though. There's some states where it's very unsettled, or there's actually negative case law around surrogacy, so that's tough. I mean, that's really tough. And then the other drawback is expensive. You have to go through a court proceeding on top of the expense of the surrogacy itself. And then unless you do get a pre-birth order, there's going to be that period of time. You don't have the automatic protection from the moment of the child's birth, which is what the marital presumption provides to people. But I'm glad you mentioned that. And then, I think it's also important to note that many states, but not all states, do have laws expressly addressing the use of donor insemination by married couples. Those are great laws for married same-sex couples. Again, for married female same-sex couples, And then, so presuming they apply with any of the requirements, like some of those state laws require you to use a doctor, most of them do require written consent to the procedure, but assuming that lesbian couple or a female same-sex couple complies with those statutory requirements, those laws should in principle apply to a married same-sex couple just the same way they apply to a married straight couple. And so far that's the way courts seem to be applying them. And then I did also want to underscore, and again I'm sure that you all know this already, but that being on a birth certificate alone does not definitively establish a person's legal parentage. Just because you are on the child's birth certificate does not mean that your parentage cannot be challenged either by the other spouse or by a third party. And that can create, I think that's so confusing for people in the community. They really, it's so hard for people not to think, oh, well, if I'm on the birth certificate, I'm done. I don't need to worry. No one's ever going to be able to contest my parentage. And I think as attorneys, it's really important that we try to, let our clients know that is not the case. And, I think just even of the situation here in North Carolina, where the Department of Vital Statistics will put both women, when a married lesbian couple, one of them has a child, they'll put both women on the birth certificate, but also under North Carolina law, the marital presumption is rebutted by evidence that a spouse is not the biological parent. So there's that vulnerability. Now, North Carolina also has a statute that says that if a married couple uses artificial insemination and there's consent in writing, then the husband is presumed to be the legal father. So hopefully for lesbian couples who are married and having children through artificial insemination and have written consent, they should be protected. But you can see there's a lot of potential issues here. Like, what about a couple who doesn't have any kind of written consent, or who used a known donor and then the known donor is playing a parental role in the child's life? Or what about married lesbian couples who have a child because one of them had sex outside of the marriage with the man, which happens maybe more than we usually acknowledge. So there's a lot of very complicated questions going on here, and my point on this is just again to underscore that being on the birth certificate alone does not resolve all of these questions. Really doesn't resolve any of those questions. I will say though that in terms of putting both parents on the birth certificate, and Denise, I think you said you talked about this in one of your workshops today. So far, almost every state is doing that. Is when a child is born to a married lesbian couple, they will issue a birth certificate at birth that lists both of the women as the child's parents, with a few exceptions, including the state of Florida, which we're suing. So then a third reason that marriage alone is not enough to protect the parental rights of LGBT people, and why it's dangerous to rely exclusively on the marital presumption, even if you live in a good state, where for a hard cold fact that under your state law, you're fine. You're a legal parent. Your parentage can't be rebutted by the absence of a biological tie. That you can know that you're good to go in your home state. But if you move to another state, they don't have to follow the law of the state in which a child was born. Every state, in fact, they don't do that. States apply their own parentage law. So even if you live in a good state and you're set in that state, you're a married same-sex couple, you move to another state, everything's up for grabs, and the non-bio parent could be very vulnerable. And that alone is a really compelling reason that every single same-sex couple who has kids, including the married ones, really has to get a court order of parentage or an adoption in order to be certain that their parental rights are going to be respected in every state. Yeah.
Practically speak population.
Well, yeah, that is such a an important question. Yeah, it's a huge barrier. Going to court is expensive, and so many people in our community don't have money to do it. They just don't. We have a joint project with legal aid organizations across the country who, of course, represent low-income clients, but many of whom don't know the law, don't know the specifics of family law affecting LGBT parents. So we have partnerships in a bunch of states to provide the local legal aid, state-based legal aid organizations with the legal knowledge about, so what do you do when you have like a same-sex couple? So I do think legal aid organizations are getting more and more up to speed on how to do these cases. I mean, what the cheapest thing for a couple to do in that situation is to just get like the equivalent of a paternity declaration. It'll be, if they're women, it'll be a parentage declaration, but that is a pretty uncomplicated, relatively low-cost avenue to get a judgment, because that's what you want to have in hand is a court judgment, because that has to be given full faith and credit in every single state, without question, no exceptions. Whereas if you're just relying on the presumption, but you never went to court, you don't have a judgment or an adoption, that does not have to be respected by other states. And we just won a case in the U.S. Supreme Court about interstate recognition of adoptions. We were representing this couple, we were representing the adoptive parent, the non-biological mom, and a lesbian couple who had children together. They used artificial insemination or alternative insemination. They had 3 kids. They adopted the kids. The non-biological mom adopted the kids in Georgia. This was before they could marry, so this doesn't have anything to do with marriage, but they adopted the kids in Georgia, did a second parent adoption. Then years later, they broke up in Alabama, and the birth mother challenged the adoption and said, oh, Alabama doesn't have to recognize that adoption. And the Alabama Supreme Court said that Alabama was not going to recognize a second parent adoption from Georgia. And I am so happy to say we filed a cert petition with the U.S. Supreme Court, and remarkably and wonderfully, just a couple weeks ago, the U.S. Supreme Court summarily reversed the Alabama Supreme Court. They didn't even require us to present additional briefing or have any oral argument. They did a summary reversal based just on the cert petition. It was unanimous. Yeah, I know. Oh, seriously. It was, really wonderful decision, and it was per curiam, so it was, attributed to the entire court, and it in no uncertain terms. I mean, they affirmed as unambiguously as we could possibly have hoped that every state has to give full faith and credit to second parent adoptions from other states without exception. And I think the reasoning and the language and the analysis in that decision would unquestionably also apply to a parentage judgment. Any judgment, whether it's adoption judgment or parentage judgment, is rock solid gold no matter where you are, even in Alabama or other conservative states that might not want to recognize them. Based on this new decision from the court, those are going to definitely have to be respected, which should be a good additional talking point or point of information for clients who still may be reluctant to believe that they need to do this. I mean, to just let them know that you have absolute certainty that your parentage will be respected in every single state if you're traveling or you move somewhere across the country. And then the last but not the least reason that marriage alone isn't enough to provide parentage protections is that tons of same-sex couples are still having children and are gonna keep on having children outside of marriage. I mean, just like straight couples do. I don't know if you've all been reading there's all kinds of new studies and reports out that, rates of marriage generally are continuing to drop in this country, and the numbers of children born outside of marriage continue to rise, and our community is not by any means categorically distinct from that, or separate from that phenomenon. I mean, tons of couples are still going to be having kids outside of marriage. So we have to find a way to protect those families, which may even be the majority of families in our community. I'm not sure anybody knows. But this is such a rapidly evolving area of law. I mean, this is completely just on fire in terms of the number of cases and litigation happening all over the country. There's, two really broad options to protect those families, same-sex couples who have kids outside of marriage. There's the possibility of statutory protections, and then the possibility of equitable protections. And on the statutory front, there are a surprising number of states now that have revised their assisted reproduction laws to expressly cover unmarried couples who use assisted reproduction to have children. The new UPA of 2002 did that, and a lot of states have done it. There's California, DC, Delaware, Maine, Nevada, New Hampshire, New Mexico, North Dakota, Washington, and Wyoming. You'll notice that none of those are in the South, but still, it is happening other places. So obviously, if you live in one of those states, it's great. You're covered. The statute applies, and both of the parents are going to be recognized as legal parents. Still need to go to court and get a judgment acknowledging that. Again, it would just be like a parentage judgment. You don't have to do an adoption; it would just be a parentage judgment. So you can't skip that step. But at least there are in some states, a growing number of states, actual express statutory protections, which is wonderful. Yeah.
Shannon, what do you do in a state like California that has that statutory protection that specifically names both parents as legal parents? What's the argument when you go to court seeking a parentage judgment? When the court might say, "Hey, statute already protects you. You're already legal parents."
Yeah. What are you doing here? Get out of my court.
Yeah.
Our experience has been in talking to family law attorneys on the ground has been the courts really understand why it's important to get the court judgment. That's for straight couples and same-sex couples. The courts are generally pretty accustomed to the idea that in the context of assisted reproduction, it adds protections, or there's an obvious reason and need to get a judgment of paternity or parentage to just remove any ambiguity and make sure that the parental rights are clear. Transportable. Yeah, exactly. And that same issue comes up with married same-sex couples who go in and get an adoption, even though under their own state law they don't need to because the marital presumption would apply. And we definitely have encountered trial courts who are a little confused by that, and their first reaction is, well, I can't grant an adoption because you're already a legal parent, or what do you want to come in here and adopt for? You're already a legal parent. But in every single case that we're aware of, and we're trying to track this all over the place, once the attorney explains to the court, and we have model briefing on this if anybody ever, that came up for you, once you explain to the court that it's necessary for interstate recognition purposes, they get it and they're happy to do it. That doesn't mean, there won't be problems in the future, but I think family courts generally, recognize it's good to get the actual judgment in hand. So that's one avenue for statutory protections for unmarried couples. The other one is, I think this one's really cool. I love these cases, but there are states that have the so-called holding out provisions. I hope this rings a bell with some people. That provision that says if an unmarried man takes a child into his home and holds the child. I always think of it as like holding the child out. I don't know what they really mean by that, but hold out the child as his child, then it creates a presumption that he's the legal father, which is really important, because if we're gonna treat marital and non-marital children equally, which we are now constitutionally all states are required to do, it's really important to have a presumption for non-marital children that corresponds to the marital presumption. So husband's presumed to be the legal father of a child born to his wife. Then an unmarried man is presumed to be the legal father of a child that he's holding out as his own. And those presumptions are kind of very analogous and kind of equivalent. Now, a lot of courts have held that, that provision should apply to women as well as to men. It should apply to same-sex couples. The issue that comes up, the two issues that come up, is whether it can be applied gender neutrally, but usually courts are okay with that so far. There's good case law on that issue, good appellate case law on that issue in California, Colorado, New Mexico, and New Hampshire. Again, not a lot of any southern states in there, but I think there will be. I think we will get some southern states to accept this theory because it's very compelling. So the two hurdles you have to get over, you have to get the court to apply it gender neutrally, and then the other issue that comes up is, well, what happens if we know that the man or the woman is not a biological parent? So it's exactly the same way that in some states, the evidence that the husband is not the biological father rebuts the marital presumption. Those same states also say evidence that an unmarried man is not the biological father rebuts the holding out presumption. But the ones that say that absence of a biological tie does not rebut the marital presumption also tend to say absence of a biological tie does not rebut the holding out provision. And that if a man has an established parental relationship with the child, established parent-child bond, especially if there's no other candidate to be the second parent, then courts are like, we're not going to allow you to rebut that presumption just because we now know, or even if we knew from the beginning, that this guy is not the child's biological father. So we've had really good luck with getting several state Supreme Courts. Like I said, the first one was California, and then several other states followed that to apply those provisions to same-sex couples. So those are the two possible statutory routes. The laws that apply assisted reproduction or address assisted reproduction by unmarried couples and the holding out provisions. And then, absolutely, you bet. Yeah, so some states have surrogacy laws. Some states only permit married couples to use surrogacy, and they have laws that say that when a married couple uses a surrogate to have a child, that the intended parents, the married couple, are the child's legal parents, and that's automatic. There's that's a rule created expressly by statute in certain states. You still have to, in some states, you can even rely on that statutory provision to get a pre-birth order identifying the married couple, both the spouses as the child's legal parents. There is no reason in the world that wouldn't apply to a gay male couple. I mean, in states that have laws that expressly address the legal parentage of children born to married couples through surrogacy, no problem, no issues with applying that equally to gay male couples, and a state would have to. I mean, based on Obergefell and constitutional requirements of equal protection, and that's what is happening in those states too. The harder thing, it gets harder when there's no laws addressing what happens when anybody uses a surrogate. And then I think your point is good. Well, every state recognizes that a man who is the biological provides the biological father in a surrogate parenting context, that he's a legal parent, and so that gives at least one of the men a hook to be recognized as the child's legal father. And then hopefully, usually in almost every state, you can figure out some way to have the other partner, whether it's a marital partner or a non-marital partner, established as the child's second legal parent through adoption or through parentage judgment. But this is really, this is really complicated. And then I know a lot of people, or it can be complicated in states that don't have clear laws on surrogacy. And I know a lot of gay male couples go to California or have a child born to a surrogate mom in California, because California is the most surrogacy-friendly state in the entire country. And you can get a pre-birth order identifying both of the men as the child's legal parents. From the moment the child is born, then they will be recognized as that child's legal parents, and then that order has to be given full faith and credit in every single state. So for gay male couples who can't afford to all the expenses entailed in that, that's a really, really solid and very secure way to establish parenting protections by using a surrogate. So yeah, it's a real good question. Last thing for protecting unmarried parents, same-sex couples, is just equitable protections. Not every state, many states have some kind of equitable doctrine, psychological parentage or de facto parentage, that provides some degree of recognition for the non-biological parent. Usually, though, it's limited to just the ability to seek custody or visitation. And sometimes also you'll entail support obligations. And this is great. It's certainly better than having no protection at all. And then there's a couple states, Washington and Delaware, and now DC too, that actually say that if somebody is an equitable parent, is a de facto parent, that they have all of the same legal rights and obligations of a parent. So that's good. But the drawback of most states is that these equitable remedies, while they can maintain a person's relationship with their child, which is great, they don't provide like survivor benefits for the child. You may not be able to get health insurance benefits for the child. They don't provide that full panoply of legal protections that you really want to have and that are tied to a fully protected legal parent-child relationship. North Carolina is another good example of that, where here somebody who's the non-bio parent who has an established parent-child relationship and raised a child with another person with that person's consent and encouragement for another person to form a bonded parent-child relationship with their child. There's appellate case law, which I'm sure all of you who practice here know super well. It says, that person can go to court and have standing to seek custody or visitation, but that's it. You're not recognized as a full legal parent. So it's important, but it's not nearly as good as having a fully recognized parent-child relationship. So really, the bottom line for all of this is just that marriage is not going to solve, all of our parentage problems. And it is like, brave new world of family law litigation out there. And whether you're married or you're unmarried, I hope I don't sound too much like a broken record on this, forgive me if I do, but the only way to be sure that you're protected is to get a judgment, either a parentage judgment or an adoption decree. Yeah.
It's not polyamorous, but I did have a South Carolina judge agree to put 3 parents in the birth certificate. And now the state won't issue the birth certificate, but I do have a court order that says mom, second mom, and sperm donor who had a relationship with the child all are legally parents. So the judge granted it. I just have to get that second part done.
That is awesome. That's amazing. And some people have gotten adoptions that recognize 3 parents at the trial court level in a handful of states. And then California actually is the first state in the country that has a statute that expressly says that a family court can, under certain circumstances, find that a child has more than 2 legal parents. So that could be relevant to some polyamorous families. It's certainly relevant to the many lesbian couples who are raising a child with a gay man who is the biological father, where all 3 of them would like to be recognized as the child's parent. So it's awesome. It's awesome for those cases. The other context I've seen the polyamorous issue come up in is just plain old-fashioned custody cases where the fact that one of the parents is involved in a polyamorous relationship is used against that parent in a child custody context. And I think we'll probably be seeing a lot more of those, and those are important cases where we need to reiterate the principle that was so important around sexual orientation, and that's still really being developed for transgender parents, which is any factor that's not directly relevant to your ability as a parent should not be used as a negative criteria in a custody dispute, because it's not about judging people's morality, it's about protecting children's best interests. And I think that's where we'll have to go with those cases. We got a few minutes left for more questions. Oh yeah.
Yeah, I was just looking up in North Carolina, we have AOC forms, administrative courts forms, that allow people to just fill in blanks. It's very convenient for lower income people who are pro se. And in the child support context, you can fill out an affidavit of parentage, but the form says mother and father, and it says you'll be prosecuted if you put any false information down and all this nasty stuff. My question is, are there any states that have reworked their forms in a way that's really useful for this population? And what kind of advocacy work could we do for our AOC forms in order to help people go in and start paying child support for their child or declare parentage?
Oh man, that is such a great point and a great question. There's a federal law that requires every state to make available a voluntary acknowledgement of paternity for unmarried fathers. And that would be and it's awesome because it's like this completely easy way, like literally like you do. You just sign. I mean, I'm sure y'all all know this. The guy just signs the form, and the federal law says that process has to be treated the same as a court judgment. So it's also entitled to full faith and credit. It's an incredibly strong protection, super cheap, costs nothing, and it's so easy. It's, would be like the greatest way possible for unmarried same-sex parents to establish their parentage. But the problem with that federal law is that the regulations implementing it, and then every state's regulations make that man, because that's what's contemplated in the statute, it's paternity, swear that he's the biological father of the child. And so that does not work, it doesn't work for same-sex couples, and it's got that really scary language about, penalty of perjury, and you can get in trouble if you misrepresent and all that. So it doesn't, right now it doesn't work for our families. And we need to change that, and I'm so glad you mentioned that, because that is being also really actively discussed in the new UPA discussions. They're trying to come up with something that would be like the equivalent for our families of a voluntary acknowledgement of paternity, which would be we really have to do this. In California, I know it's been discussed, and legislation to do that has not yet been affirmatively put forward, but I think it will be soon. And there's no reason it would be very, very easy to do that. It's just something that we have to wrap our minds around the need for. But that would go such a long way toward resolving the issue that you raised earlier about the costs. And really for most low-income families, they're not going to be able to get the security that I'm keep talking about, because they're just they're not going to be able to go to court, even if it's a relatively simple procedure, because it's still time and some degree of some expense and money. So I think that's got to be an important part of our future advocacy right there, like a really important part of it. Milan, will you help me tell people about the Family Law Institute?
Absolutely. My name is Milan Pham. I'm a member of Nicholson Pham Attorneys at Law. Let me go there.
Oh yeah, please. Yeah.
My name is Milan Pham. I'm an attorney at Nicholson Pham Attorneys at Law. More importantly, I'm a member of the LGBT Bar of the National American Bar Association, and I'm a member of the Family Law Institute, which is a division of the LGBT Bar. And it's comprised of attorneys who practice family law and are working diligently on these issues of parentage and creating families, how to work with polyamorous families, and how to create parentage intentionally the way our community has been, and to have those parentage relationships recognized under law. The Southeast region of FLI is meeting in Carborough in April. April 15th through 17th. NCLR will be there, Family Equality Council will be there, Lambda will be there, and we need our local practitioners to come as well. It's capped at 35 people. Meredith and I have brought a couple of the invitation letters, so anybody who is interested in going actually has to apply to be a member of the LGBT bar and has to be vetted by the Family Law Institute prior to being admitted. There is no CLE credit that will be given. It is